The Weaponization of Victimhood, a candid look at the inexcusable bias in family courts. A provocative statement sometimes heard in discussions of divorce is that a woman's greatest strength in family court is her ability to be a victim. That sentence is offensive when treated as a universal truth. Women are individuals, and many women are genuine victims of serious abuse. But the statement points toward a real problem just the same. Victimhood can become a litigation role that courts assign too quickly, and that role is often gendered and abused. One recurring pattern begins with a rewritten marriage. For years, a wife may describe her husband as a good father, provider, and a loving spouse. After separation, he is described as abusive, coercive, and terrifying throughout the entire relationship. That change does not prove the allegation is false, of course. Genuine victims may hide abuse, protect appearances, fear retaliation, or struggle to recognize what is happening. But prior praise is still evidence. Affectionate messages are evidence. The absence of contemporaneous complaints is evidence. The timing of accusations is evidence. None of those facts is conclusive, but none should be automatically discarded. The system becomes unfair when it creates an unfalsifiable loop. Why did she praise him? She was afraid. Why did she initiate affection? She was maintaining peace. Why did she encourage others to trust him? She was protecting herself. Why did the allegation arise only when the divorce or child custody dispute began? She finally felt safe. Any one of those explanations may be true. The problem is treating everyone as necessarily true. When supporting evidence proves abuse and contradictory evidence also proves abuse, the allegation can no longer be tested. Judicial risk aversion makes the problem worse. Judges know that denying protection to a genuine victim can have catastrophic consequences, both to the victim and to the court. Granting an emergency order may thus feel safer, but an ex parte order can remove a person from the home, interrupt parent time and relationships between parents and children, restrict property access, and shape the custody case before a full hearing occurs. The harm of an erroneous order may be quieter than the harm of denying protection, but it is still real. There is also a double standard. Fear in a woman may be treated as evidence of victimization. Fear in a man may be treated as weakness, strategy, or mutual conflict. Conduct viewed as threatening when committed by a man may be excused as emotional volatility when committed by a woman. The solution is not to reverse the prejudice. Courts should not presume women are lying, and they should not recast men as the true victim class. The solution is one evidentiary standard for everyone. Identify the specific alleged acts, require detail, compare the account with messages, witnesses, records, and surrounding circumstances. Consider trauma, real trauma, as one possible explanation, not a universal solvent that dissolves every contradiction. Consider motive without treating motive as automatic disproof. Keep the burden on the party who bears it. Real domestic violence is a tragedy. Genuine victims need swift and effective protection. But false or exaggerated claims consume resources, damage innocent people, some cases irreparably, distort custody decisions, and make truthful claims easier to doubt. Family court should not assign the role of victim and abuser based on sex. It should determine what happened based on evidence.